Thanks very much. And now we have the government of Egypt. Thank you very much, sir. Please introduce yourself and begin your testimony.
Thank you very much. My name is Maged El-Sayed. I'm First Secretary at the Egyptian Embassy in charge of the economic and commercial. Well, ladies and gentlemen, good morning, and I'm sorry not keeping the tradition of the other language. I'm not. Before I give you a heads up of the development that happened in the IPR field in Egypt, I would like first to share with you the methodology that was used in reaching these conclusions. Up till 2008, Egypt was on the priority watch list in the Special 3.1. Starting 2008, it is on the watch list, and up till 3 years ago, we started a new methodology, which is looking at the root cause of being in the watch list and try to fix the problem from the source. And during the past 3 or 4 years, we have been working closely because we noticed in the Special 3.1 that the main problem was in the IPR with the pharmaceutical company. Specifically, not in other domains, because we've been going through also the testimony of the public testimony that is published on your website. So that's how we worked, and we worked closely with the companies to address their problems, to address the main issues, and we also took into consideration all the recommendations that were presented in the previous Special 3.1, and we worked on ameliorating the IPR situation and standard in Egypt, which is well illustrated in the reports that I have submitted to you. Let me go through some of the development that were done in the regulation and decrees regarding the IPR in the pharmaceutical sector. In specific, the Ministry of Health issued decree reorganizing the registration procedures of human medicine. The decree emphasizes on the importance of companies' commitment to the intellectual property rights, and the Article 9 of this decree states that the companies are committed to provide a pledge acknowledging their commitment to the provision of IPR law of 2002, which is the same as stated in article which regulates the procedures of registration of biopharmaceuticals, vaccines, and blood products. Another decree that was issued regarding the IPR, which is the pharmaceutical track and trace system, that was issued in order to control the Egyptian pharmaceutical market and secure safe and appropriate pharmaceutical supply and product against counterfeit medicines. I'm giving also notice on another regulation which was a major problem for the pharmaceutical companies that we addressed, which is all registration procedures, which is submission of product, are done in parallel, which leads to shorten the registration process and make medicines available at the market as soon as 6 to 8 months and up to maximum of 18 months. This is instead of previous 3 years maximum times. The number of companies that are allowed to register their product is open. That gives the chance for more foreign companies to register their product in Egypt. One of the very important point that was achieved, and we got recognition from many companies regarding the fast-track system for registration was developed. The system is applied by default on products which were registered through the fast-track program in the US FDA. So in addition to other criteria set for that purpose. There was also a breakthrough in the field of medicine and seeking to register new pharmaceutical in Ministry of Health as soon as it was registered. Many products for hepatitis C treatment were registered in a period of 8 months. Other than the rules and decrees, the Ministry of Health participated in a round table that include most of the pharmaceutical companies, the US pharmaceutical companies. This ongoing cooperation between the ministry and the private sector stakeholders mentioned above resulted in a set of processes intended to working to advance this sector and joint effort to raise the quality of healthcare in Egypt and thus the quality of life for the Egyptians. Back to the report submitted. We have a testimony that was submitted from Pharma in 2016 that says during the past several years, Pharma and its members companies have tried to work in good faith with the Egyptian official to address health and industrial issues. While serious challenges remain, Pharma notes that for most part, Egyptian officials have shown willingness to meet and discuss issues concerned and have expressed interest in supporting the innovative biopharmaceutical industry and encouraging investment in the country. This is regarding Pharma. As for Bio report in 2016, I can quote from them that during 2015, Bio continued regular outreach to Egyptian officials and notes the willingness of government representatives to engage on policy issues affecting patients and healthcare system and the innovative life science and biopharmaceutical sector in Egypt. Bio notes that as part of Egypt's drive to strengthen its competitiveness in the sector, government officials have demonstrated a willingness to analyze challenges and engage in meaningful dialogue. Part of the report I have submitted, it includes testimony that was submitted to the USTR from major US companies, and I quote them: "This decision by the Egyptian Health Ministry sends a reassuring signal to investors and companies operating in Egypt that government recognize Egypt's commitment to modern intellectual property standards and will take measures to uphold these rights." Another testimony said that the Egyptian government has embarked on a renewed partnership with innovative pharmaceutical industry. So in conclusion, based on all the previous positive developments, evidence-based facts, and testimonies with regard to the Egyptian IPR environment, we strongly request the removal of Egypt from the watch list status in Special 3.1 because this removal will send a message from the USTR that these efforts are being appreciated, encouraged, enforced, and to be continued based on the effort we have made. Thank you very much.
Thanks very much. If we can go to our first question from our colleagues at Department of Justice.
Thank you. So Egypt's submission to the United States this year in the Special 301 process and also your testimony is focused on the pharmaceutical sector. However, Egypt is today probably the largest market in the whole Middle East for pirate and counterfeit goods, mostly imported from China. As you know, many shops in Cairo and other Egyptian cities sell infringing mobile phones, clothes, computer parts, and other hard goods, as well as pirated movies, software, games, books, and other copyrighted works. This unlawful activity has reduced tax revenues that should be paid to the Egyptian government and discouraged direct foreign investment in the country. For example, one recent study found that just a 10% reduction in software piracy alone in Egypt could generate hundreds of millions of dollars in increased gross domestic product. Could you explain what Egypt has done in the past year to improve enforcement against trademark and copyright violations?
I would be pleased to send your request to the specific authorities and get back to you in the post-hearing comments. However, I just couldn't help notice that in the 2015 submission for the International Intellectual Property Alliance last report requested in their testimony to Special 3.1 that Egypt be omitted from the list, and we were referring to this, that there is no problem regarding the counterfeited or the piracy of softwares in Egypt. However, I'm pleased to address your question and send it to Cairo.
I think the software piracy rate is probably over 60%. And having been to Cairo in the past few years, I can assure you that there's plenty of pirate and counterfeited goods readily available.
I'll make sure I get back to you.
Thank you.
Thank you.
Thanks very much. For our second question, Department of Commerce.
Thank you. 2012 pricing decree number 499 would have treated foreign-made products differently than Egyptian-made products. That decree was discontinued, but my question is whether there are plans to replace it, and if so, will it be replaced with a decree that is more transparent and less discriminatory?
I'm willing to send also your questions and get back an answer. However, regarding that you have actually answered that first part, that the decree was discontinued. Most of the companies I meet and here in the U.S., they are requesting that regarding the pricing issues, there should be moving around regarding the prices, and they have requested. And let me tell you this correctly, that most of the pharmaceutical companies are on board of a committee headed by the Minister of Health, and they submit their request regarding the decrees and recommendation, and it's taken into consideration their request. They are part of the team working on this, and they have asked to release the prices gradually, even on 5 products per year, so they can pick like 5 products and start releasing the price on these products. However, I could get you a further detailed answer. Thank you.
Thanks very much. So that concludes our panel of government commenters. We now invite the American Apparel and Footwear Association. And just as a reminder to everyone, we have my colleague Stephen Mitchell from the Department of Commerce providing some time cues. And again, should you not, or should you wish to amplify your comments here with further information, of course, we do have post-hearing rebuttal submissions that are also available, and those will be due March 4th, and I'll give more information at the end. So with that, welcome. Please introduce yourself, sir, and begin your testimony.
Great. Thank you for providing an opportunity to testify this morning. My name is Steve Lamar. I'm Executive Vice President of the American Apparel and Footwear Association, the National Trade Association representing apparel, footwear, and other sewn products companies and their suppliers which compete in the global market. We represent more than 1,000 world-famous name brands. Our membership includes 340 companies drawn from throughout the supply chain. AFA is the trusted public policy and political voice of the apparel and footwear industry, its management and shareholders, its 4 million U.S. workers, and its contribution of $360 billion in annual U.S. retail sales. We very much appreciate the opportunity and the attention the U.S. government shows to the defense and protection of U.S. intellectual property rights worldwide. We consider the U.S. government a strong partner in this area. For its part, AFA has been very active and vocal in the promotion and protection of U.S. IPR for the apparel and footwear industry. In addition to our active participation in the annual Special 301 and Notorious Markets reports, we work with our Brand Protection Council to educate policymakers and other stakeholders on the importance of strong IPR for our industry. Success on these issues supports U.S. apparel and footwear jobs, particularly since our members' competitiveness is highly dependent upon the global protection of the intellectual property embedded in their designs, their brands, and their images. We estimate that intellectual property theft costs our members upwards of $68 billion in 2013. This is a figure that has no doubt increased as this problem has worsened. In our comments, we compiled a detailed list of countries where systematic IPR enforcement problems exist and where IPR practices need to be improved. Our submission also highlights some successes in countries where AFA members have traditionally faced resistance to the protection of their brands. In total, we identified 15 countries. We relied heavily on our members in the development of this list. They provided recommendations based on their direct experiences working with foreign governments, including enforcement agencies, intellectual property policymakers, other IPR stakeholders, and foreign judiciaries. A number of our members are active in dozens of countries, enabling them to make comparisons over time and between jurisdictions. Their enforcement activities also give them firsthand experiences conducting raids, observing the incidence of counterfeit products in notorious markets, and understanding if IP deficiencies can be remedied through additional resources, changes in laws or judicial practices, or an increase in political will. In the comments, we also raised concerns related to foreign internet registries. Counterfeiters are increasingly using the internet to expand their business while shielding their illicit activities from enforcement efforts. They are registering domains that advertise and sell counterfeit goods and infringe brand owners' trademarks, both in the domain name itself and in the content of the website. Many of these counterfeiters use a country code top-level domain in order to avoid detection by the United States brand owners and enforcement of United States court orders. Individual top-level domains have varying requirements and fees for registering domains. However, most top-level domains do require that the website registrant be a citizen or have a registered office in the country in question, and that the registrant provide true and complete contact information upon registration of a website. Most of these top-level domains also have policies against cyber squatting. All that is good. But despite these registration requirements and policies, a number of foreign registries do not make registration information publicly available and don't provide information or assistance to brand owners whose intellectual property rights have been violated on a website using top-level domains. We also note that many top-level domains are not subject to the ICANN consensus policies, such as the Uniform Domain Name Dispute Resolution Policy. This adds another hurdle to the enforcement of intellectual property rights against bad actors on the internet. Finally, our comments address three cross-cutting issues that I'd like to raise here. First, facilities that make knockoff shoes, clothes, and accessories do not typically meet the high standards or comply with the regulations upon which our members insist to ensure product safety, worker safety, and workers' rights. In addition to stealing the identity of world-famous brands, counterfeiters put millions of workers in danger through substandard conditions while exposing consumers to unknown product safety risks. Second, as we note in several of our country comments, we're hopeful that the recently concluded Trans-Pacific Partnership will help improve recognition and enforcement of brands worldwide. While it is expected to have an immediate impact on the countries who have signed on to the TPP, we hope it will have a beneficial impact on countries that are currently outside the agreement. It is with this in mind that we urge the expeditious approval and implementation of the TPP, including the IP provisions, in all 12 countries. On a related point, we remain concerned that so many existing free trade agreement partners continue to demonstrate insufficient production of IPR. 40% of the countries we nominated this year are FTA partners, including Mexico and Canada, which are also part of the TPP. It is simply not acceptable that FTA partners are unable to ensure high levels of protection and cooperation on this important right. And finally, we applaud the process in the United States to coordinate interagency IPR enforcement and priority setting in an office in the White House through the IPEC, the Intellectual Property Enforcement Center. Knowing that the administration is hoping to replicate this approach in other countries, we would recommend that you use the Special 301 report to call out those countries that have successfully adopted the same mechanism. I appreciate the opportunity to raise these concerns and look forward to working with USTR and other U.S. government agencies to address intellectual property rights issues worldwide. And I look forward to your questions. Thank you.
Thanks very much. For our first question, Department of Justice.
Thank you. Thank you for your testimony today. You mentioned in your testimony and also in your submission that counterfeiters deliberately register, at least some counterfeiters deliberately register their domains with certain country code top-level domains, CCTLDs, to avoid detection and enforcement by brand owners. In particular, you single out as especially problematic CCTLDs in Sweden, Spain, Germany, Denmark, the Netherlands, China, and Switzerland. As you know, some CCTLD managers voluntarily follow ICANN's UDRP, the Uniform Domain Name Dispute Resolution Policy, and some also agree to let a panel of the World Intellectual Property Organization, WIPO, resolve their disputes. So we appreciate you flagging the issue, but what specifically do you believe ICANN, WIPO, and or the U.S. Can and should do about this matter?
One of the things we're trying to do is raise awareness of this, that there's inconsistencies, that there is a greater migration of counterfeit problems onto the internet. And that's manifesting itself in a number of different ways as counterfeit goods become directed into smaller and smaller shipments. For example, we are hoping that either through the ICANN process or maybe through WIPO, that there will be an opportunity for best practices to be learned and applied across all the countries, so there's more consistency.
And also as a follow-up to this matter, I think we had at least a couple submissions suggesting that the committee should not address this issue in the Special 301 report. How would you respond to that?
Well, as I said, I think as the counterfeit problem begins to magnify, or already is, in the internet, probably we should be putting more and more attention onto the way in which the internet is used to as a traffic for counterfeit goods, and what governments and the other stakeholders in the internet space can do to help prevent that. So I would disagree with that recommendation.
Great, thanks very much. Next question from the Department of Labor.
Hi, good morning.
Good morning.
You had mentioned in your testimony that, that the lack of property protection and highlighted particular problems with specific countries in your written submission. And you had said that 68 billion in losses. But can you break that out any further? I mean, in terms of specific countries or percentages in terms of, legitimate versus illegitimate, by country? I mean, are you able to do that? That would be more interesting to find out as we look at the various countries. And as well, you also talked about that employers who the employees themselves who make these knockoff shoes and clothing work in facilities that don't typically meet high product standards or comply with regulations to ensure product safety, or worker rights. And based on the amount of illegitimate product out there, do you have any idea in the scale in terms of number of workers that work in this illegitimate economy?
So to answer to your first question, we didn't do a country breakout. What I would do is point to the customs numbers that they generate. It's a good proxy for the sources of counterfeit goods. And the European customs agencies, they publish comparable numbers. So that's kind of a good indication that maybe it's, we're seeing those numbers really across the world that same way from a country breakout perspective. I don't have specific numbers on which on the scale of the problem, and this is actually something that we're working on, trying to develop more data on this. There's certainly a lot of anecdotal evidence on that, where when folks conduct raids, they'll just see casually that there's evidence of improper work conditions, improper work environments, and certainly when counterfeit goods are intercepted, tests that are performed on them will find that they don't meet, for example, the restricted substance list requirements or other product safety requirements that our companies have to meet, whether it's in the United States or in other countries. And so this is something we're trying to develop more information on too, but again, wanted to flag it because we do think it's an area that needs a lot more work.
Thank you.
Just a quick follow-up from
Sure.
the Department of State.
I just want to ask you quickly about whether one of the issues you're looking at in terms of infringement is fabric issues, because it didn't appear to me that was mentioned in your statement. Just the high-tech fabrics of like super wicking sportswear and Levi's fabrics and so on.
Yeah, we didn't call out that specific level. I mean, there's a couple of ways in which fabric issues will come up. Either it's through patent issues such as the ones you mentioned. There's a whole area of concern relating to the copyrights that go on to the copyrights of the designs that go onto the fabrics too, and that's probably more of a domestic legal problem that we're encountering. But again, one that extends back into the countries where product is produced because of the lack of a clear and consistent library to find designs and to make sure that you're using the legitimate design, for example. So that is an area that we work on, but we didn't call that out in our comments specifically. I suspect as smart fabrics become more prevalent in the marketplace, you'll be seeing that more in our comments in the future.
Thanks very much, and thank you for your testimony.
Great, thank you.
Next, if we can invite the Alliance for Fair Trade with India, please. Thanks very much. Welcome, sir, and please introduce yourself and begin your testimony.
Good morning. I'm Brian Pomper. I serve as the Executive Director of the Alliance for Fair Trade with India. Good morning, and thank you for providing me with the opportunity to testify on behalf of the Alliance for Fair Trade with India. The Alliance for Fair Trade with India, or AFTI, was launched in June of 2013 in support of increased action to address the barriers to trade and investment U.S. companies are facing in India, including the erosion of intellectual property rights, and to serve as a mechanism for engaging with U.S. policymakers on these issues. AFD's diverse membership is comprised of organizations representing a range of U.S. industries adversely impacted by India's IPR policies and practices. In light of this mandate, I'm here to call on USTR to again place India on its priority watch list and to conduct another out-of-cycle review of India's IPR regime. AFD and its members were encouraged by the Obama administration's efforts at commercial engagement with India over the course of the last year. Our members watched with cautious optimism as the two countries held their first ever strategic and commercial dialogue and a meeting of the U.S.-India Trade Policy Forum in the fall of 2015. However, despite the convening of these dialogues, the Indian government has yet to take any significant steps towards improving the business climate for innovative American companies. In fact, numerous long-standing issues remain unresolved. These include weaknesses in the Indian copyright system that harm U.S. and Indian creators alike, the use and threatened use of compulsory licensing on biopharmaceutical, environmental technology, and other products as a tool of industrial policy, and measures in Indian law that add a legally questionable additional criterion for the patentability of medicines and agrochemical products. Additionally, AFD and its members have serious concerns with several of the policy pronouncements and proposals included in the version of the national IPR policy leaked in April of 2015. As an extension of a campaign promise made by now Prime Minister Narendra Modi, the Department of Industrial Policy and Promotion constituted a think tank, the National IPR Think Tank, in October 2014 to draft the national IPR policy. NIT has since drafted and circulated a revised plan which was leaked to the public in October of last year. Among the most disconcerting aspects of the document are plans for increasingly onerous local manufacturing requirements and a continued failure to ensure regulatory data protection. These issues have been long-standing frustrations of AFD and its members, along with many other innovative American companies. The continued failure by the Modi government to address these and other issues has left AFD and its members concerned by the apparent disconnect between the diplomatic momentum, positive rhetoric, and commitments emerging from the recently convened dialogues, as there has been little concrete movement on key issues. Particularly as we enter the final year of the Obama administration, we are left wondering how can these bilateral forums be used to productively address the issues we have repeatedly highlighted in these and other fora. We agree with the sentiment USTR expressed in announcing its 2015 Special 301 report that, quote, attention to our IPR priorities and action to resolve concerns through bilateral fora can benefit both the United States and India. We note that USTR stated it expected India would make substantive and immeasurable improvements in India's IPR regime for the benefit of a broad range of innovative and creative industries. USTR added that it would, quote, monitor progress over the coming months and is prepared to take further action if necessary. As detailed above, we believe that India has not made substantive and measurable improvements in its IPR regime for the benefit of a broad range of innovative and creative industries, and that therefore further action in the form of an out-of-cycle review at a minimum is warranted. For these reasons, we recommend maintaining India as a priority watch list country and would encourage the U.S. government to maintain its focus on key IP issues by implementing a new out-of-cycle review. We believe that this increased pressure and oversight is necessary to make progress and to avoid backsliding on issues of concern to AFD and its members. Thank you for your time and for what we know are your constant efforts to address these issues as meaningfully as possible in what has long been, and I'm certain will continue to be, a challenging environment. AFD appreciates all the U.S. government has done and we know will continue to do to try to improve the U.S.-India trade relationship.
Thanks very much. With respect to the questions, can we start with USTR, please?
Some of the submissions, including your own, note some actions that the government of India has taken in the past 12 months, including reports of court and enforcement authorities taking action and deterring the unauthorized use of satellite reception boxes, the court's issuance of John Doe injunctions against cable operator piracy to curb the spread of pirated sports broadcasts, denial of compulsory licensing requests for patented pharmaceuticals, and court rulings that uphold patent rights for pharmaceutical companies through the granting of injunctive relief. I'm wondering how how you would characterize those actions that have been taken over the past 12 months.
Yeah, I think there have been some positive developments, and I should say FD is much broader than just IP, and so we look at sort of the broad sweep of different actions that India takes, and there have been some positive movements. I would say maybe 2 steps forward, 1 step back. There are some major issues that are of long-standing concern both to AFD members and I know to the U.S. government that we really haven't seen much movement on at all. I would say data exclusivity, 3D, a bunch of the other measures that I know you're all very well familiar with that I think would have the greatest impact. So I guess my answer is we'll take the wins where we can get them, but there's a lot more to be done.
Thanks. For our second question, Department of State.
Thanks very much. One of the new initiatives that Prime Minister Modi has announced is this so-called Made in India outreach. And I wanted to know if you had views on how it intersects with India's intellectual property regime. And relatedly, I also wanted to know how companies are responding to the IP problems that you see, whether you are seeing less investment, less trade, some of those types of issues.
Thank you. Good questions. First, on Make in India, I think as a general policy matter, there's nothing wrong with a country saying they want to try to increase their domestic manufacturing. We have this in the United States. Sure, and Steny Hoyer has Make It in America, his program. The difference is a lot of these programs focus on incentives and training and these sorts of matters rather than forcing countries to invest in India or to invest in country. There are parts of Make in India, the one that I can think of immediately right here, there was a suggestion in the draft national IPR policy that entities that commit to manufacture in India would get expedited review with the patent office. Those sorts of things I think we would not support. We think that's a negative aspect of Make in India. And in terms of how countries are reacting, it is often the case that those who are defending India's practices will say, well, look at the investment flows into India. And I would say there certainly is investment in India, but if you look at what kind of investment, there may be a plant being cited in India, but they won't do any of the sort of high-value R&D innovative research there, and they affirmatively won't do that because of the poor IPR regime. And of course, I think we all think that's where truly the high-value employment is headed.
We have time for one more quick question from the USPTO.
Thank you. Your remarks and submission raise a number of issues, patent, market access, copyright, and trade secret, that affect different industries. Can you give a sense of which of these are AFD's priorities, or which areas do you see as being the most likely candidates for progress in the short term?
It's a good question. I mean, these are, of course, many very long-standing, very difficult issues, and I don't think we are Pollyanna-ish about the prospect of solving them in the near term. But we think that the U.S. government has done a great job pressing India on these issues, and we hope will continue to do so, because we think not only can you make progress that way affirmatively on the issues that we raise, but also to perhaps keep other bad policies from cropping up, and also importantly to keep other countries from maybe looking at India as a guidepost for the kind of development policies they should include. It's hard for me to pick and choose which of these are more important than others. They're all things that different aspects of AFD, which is it's a coalition of associations. So they each have their different issues that they care most about. It's hard for me to really pick among those. So.
Great. Thanks very much for
Thank
your
you.
testimony. If we can invite the Business Software Alliance. Welcome. Please introduce yourself and begin your testimony.
Good morning. My name is Leticia Lewis. I am the Director for Policy at Business Software Alliance. Thank you, Madam Chairwoman and members of the committee, for the opportunity to testify on behalf of BSA, the Software Alliance. BSA and our members share your goals of protecting intellectual property rights, and we offer these comments to contribute to your efforts. BSA is the leading advocate for the global software industry in the United States and abroad. Our members are at the forefront of driving the global digital economy and invest substantial resources into developing cutting-edge technologies. These companies strongly rely on intellectual property protection in order to continue innovating. BSA members receive half or more of their combined $600 billion in annual revenues from overseas. That revenue number, $600 billion, is many times greater than all other copyright-intensive industries combined. Given the amount generated from overseas, removing barriers to trade is essential to BSA members' long-term success, but more importantly, essential to the American economy. It's undeniable that adequate and effective intellectual property protection and enforcement remains critical for our members, but fair and equitable market access, an often overlooked component of Special 301 consideration for many years, is even more important. We urge you to focus on this prong of the Special 301 and use this process to forcefully and clearly establish removing market access barriers as a dispositive criterion for your determinations. In terms of intellectual property protection and enforcement, the main issue faced by BSA members is the continued use of unlicensed software by government agencies, state-owned enterprises, and businesses. According to the latest information available, the commercial value of unlicensed software globally exceeds $60 billion. The software industry is the only industry that actually measures the economic harm done by illicit use of software. I know this to make a key point. Losses are extremely large. Illicit use of software is 43% of total global software use, and in too many countries, it exceeds 60%. BSA also remains highly concerned about inadequate enforcement of unlicensed use of software in many countries. Software today is more and more often downloaded online or used on remote servers, such as through cloud computing services. It is therefore critical that appropriate regulatory environment prevent circumvention of technological protection measures in the digital environment. The inability to properly protect trade secrets, including source code and other proprietary information, is also a concern for BSA members. Patent protection is also extremely important to our members. It is paramount that countries provide effective patent protection to eligible computer-implemented inventions in line with their international obligations. Since our Special 301 submission, we've had a very troubling development in India. On February 19, the Indian Patent Office issued revised guidelines on the patentability of computer-related inventions. The new guidelines may prevent many software-enabled innovations from receiving patent protection in India. They direct the patent examiner to look for a novel hardware element in addition to novel software for the invention to be patentable. This is a very negative development, one which places India in a unique posture that is out of step with international practice and potentially in violation of its TRIPS obligations. We are currently reevaluating our recommendation in our Special 301 submission, and you'll send you a letter supplementing our views. BSA is deeply concerned about steps several U.S. trading partners are considering or have taken to erect digital trade barriers, denying fair and equitable market access to U.S. companies. For example, policies that restrict cross-border data flows are detrimental to the economy as a whole. Data-related market access barriers requirements take many forms. Sometimes countries expressly require data to stay in country or impose unreasonable conditions in order to send it abroad. In other cases, they require the use of domestic data centers or equipment. Recognizing the trade disruptive impact of measures that impede cross-border data flows, the United States insisted and succeeded in including specific prohibitions against such practices in the recent concluded Trans-Pacific Partnership Agreement. BSA strongly supports this important outcome and urges the United States government to seek similar results through all available trade mechanisms, including Special 301. In addition, we are concerned that governments around the world are using or proposing to use security concerns to justify the creation of trade barriers. China's recently enacted counterterrorism law and draft cybersecurity law are key examples. We are also concerned that a number of countries are imposing significant restrictions on foreign suppliers' ability to serve public sector customers. Finally, a number of countries have developed or are developing country-specific standards for software and related services. This creates a de facto trade barrier for BSA members, raising costs of cutting-edge technologies for consumers and for customers and enterprises. Addressing the challenges that I've summarized today, it will be critical for BSA members to continue to power the digital economy. In our submission, we recommended that markets including China, Indonesia, and Russia be listed on the priority watch list, and Brazil, Mexico, and Korea, among others, be listed on the watch list. In many cases, we've identified market access issues in this market as equally important for your review and consideration as to whether the trading partners provide adequate and effective intellectual property protection and enforcement. BSA and its members thank the USTR and all agencies of the Special 301 Subcommittee for your efforts to address inadequate and ineffective intellectual property protection in countries that are U.S. trading partners. We also urge you to use the Special 301 mechanism to focus even further on a variety of policies that deny fair and equitable market access for BSA members and other companies who rely on intellectual property rights. Thank you very much for your time.
Thank you very much. For our first question, look to the Department of Commerce.
Thank you. We were hoping you could speak a little bit more specifically to the country-specific technology standards that you referenced and how they're hurting software companies, particularly in China, India, Nigeria, and Vietnam. And as a second-level question, is BSA recommending particular approaches or particular solutions that these countries should consider in setting those technology standards?
Absolutely. Thank you very much for your question, a very important one. So just to be clear, BSA doesn't recommend the use of any specific standards. The one ask that we have for all governments is that they use standards that are global and that they are voluntary and that they are created through a mechanism that includes multi-stakeholder engagement. And this is so because the standard that will come out of this process will be much more effective, and in this way, countries can rely on this, all these experts that get together to create the standards. So our recommendation to all governments in our exchanges has always been this: we don't necessarily point out to the use of any one specific standard, but that they will use these global standards, as I mentioned. And in terms of how, the second part of your question, I think, is how these countries are doing that. They do that in a variety of ways. It's not necessarily just regulations that refer to standards, but sometimes these requirements come through other pieces of legislation or different regulations. And this is really detrimental. Sometimes they will be regulating an area that's not necessarily standard related, but they will include some standard requirements that in most cases will ask industry to rely on domestic standards, which is very detrimental.
Thank you. Your second question comes from the Department of State.
Thank you very much. I think we're very eager to see what your supplementary submission on India will say about those new issues that you mentioned. My question relates to Greece, where you specifically stated, I think in your submission, that the government uses little criminal enforcement to combat piracy. And I'd like to know if you can state whether that is an issue related to bandwidth or to a lack of political will.
To the first part of your question, again, the India development is a very recent one, so we are looking into that, hoping to be able to offer more information as soon as we're able to. And to the second part of your question, I think it's a mix. I think that's both. I think that's there is definitely the need of more political will to address the issue in Greece, but there's also lack of resources, and I think that it goes hand in hand, because to the time that they establish that intellectual property protection is a priority, then they may start changing things around in terms of budgets and allocation of necessary resources to address the issue.
Thank you very much. and
You're
Thanks for your testimony.
Thank
Next, if I can invite the Computer and Communications Industry Association. Welcome. Can you please introduce yourself and begin your testimony?
Hi, my name is Matt Shears. I'm VP in Law and Policy at the Computer and Communications Industry Association, which is a trade association of internet and technology firms that has promoted openness, competition, and free trade for over 40 years. Our written submission and my comments today urge USTR to take action on two issues. First, a problematic trend identified as ancillary copyright, in which countries deny market access and adequate and effective protection of rights guaranteed under international IP law through the creation of a sui generis pseudo IP right in quotations. And secondly, I'll address the importance of insisting on complete implementation of important intermediary liability protections that we have included in international agreements to date. So first, let me focus on the question of ancillary copyright. This term, ancillary copyright, is sometimes referred to as a quotation levy or a snippet tax, and under any label, these provisions are inconsistent with international IP norms. In 2010, actually, I appeared before this panel having warned that at some future date, foreign countries might, in fact, abrogate these commitments to allow for free quotation, and should that happen, the Special 301 process should identify those as inconsistent with IP norms. And today, that day has arrived. There are these snippet taxes appearing in multiple countries. Our testimony, our written submission, focuses on two: Germany's 2013 Leistungsschutzrecht, under which automated search indexing can lead to liability, providing only for a exception of the smallest text excerpts, which German authorities recently seem to have construed to mean 7 words or less. Similarly, in 2015, Spain legislated a reform of their Ley de Propiedad Intelectual, in which they created a similar quotation levy vesting unwaivable rights in publishers of online news content, such that electronic aggregation services are taxed even for using, quote, non-significant fragments of aggregated content. And as a result of this law, several US and actually Spanish news aggregators exited the market, including news.google.es. As you surely know, Spain has recently been the subject of an out-of-cycle review for other aspects of IP compliance, and our view is that there's no principled reason why this issue should not also be the basis for inclusion in an evaluation of where Spain is out of compliance with IP law. I'll note that it only recently came to my attention that, in fact, today, a provision which appears to be a sort of ancillary copyright for image indexing has advanced in the French legislature, and my suspicion is that principles like this, proposals like this, are likely emboldened by our acquiescence to these legislative initiatives in other European countries. So just as is described more fully in a written statement, it's fairly clear that these snippet taxes violate Article 10.1 of the Berne Convention, which requires free use of works. Article 10.1 pertains to news quotations, quotations and news of the day, and that is incorporated by reference into TRIPS. It states that it shall be permissible to make quotations from a work which has already been lawfully made available to the public, provided that's consistent with fair practice, and Berne specifically says, including quotations from news articles and periodicals. USTR has previously watch-listed countries for TRIPS violations, and frankly, European countries should not get a pass. So let me just finish by saying a few things about non-compliance with international norms on intermediary liability protections. In a variety of international instruments, most of our free trade agreements going back to 2003, in TPP, in the European e-commerce directive, we have seen the evolution of protections for online intermediaries. The United States created the gold standard for intermediary protection in the mid-90s, and that norm has spread around the world. And in some countries, we frankly don't see as much effort in complying with obligations that have, in fact, enacted these. Our written submission focuses on Australia, which entered into an FTA with the United States in 2004 and agreed to create a series of protections for online intermediaries. But over a dozen years have passed since that obligation came about, and the Australian law today only protects its domestic carriage service providers, and it doesn't protect online intermediaries like U.S. companies that are exporting services to the Australian market. Generally speaking, I think both of these items indicate that it's time that this process place a greater emphasis on ensuring that the balancing provisions in international IP law are part of our international policy. That was identified in the 2010 Joint Strategic Plan, and it should be an ongoing part of our Special 301 process. I'm happy to take any questions about that.
Thanks very much, Matt. Your first question comes from USTR.
Can you elaborate on your views of the statutory and legislative history of the Special 301 statute that that provides for your recommendation, specifically the IP protection and enforcement and market access barriers for U.S. persons that rely on IP?
Yeah, absolutely. So I think this has been described in greater depth in some of our Special 301 submissions over the past few years. But generally speaking, 2242A 1B provides, if I have that right, provides that U.S. persons that rely on intellectual property are to be granted the same entitlement to protection under Special 301 as what we might think of as protection for the traditional intellectual property goods, patented products, copyrighted works. And no doubt that language it was designed to reflect that the export of goods, cultural goods or patented goods was not going to be the only business model that U.S. persons would rely upon. Indeed, the United States is largely a services economy, and if we interpret 2242 to exclude the exports of services, in a few years it's likely to be a largely irrelevant provision. Much of the issues that I'm describing, and indeed that my colleague from BSA described, involve the export of services. And for that reason, we need to think about 2242A as providing for services that depend on intellectual property. And indeed, many of the online services that were explicitly targeted in the legislative history, if one drills down into what these countries are talking about when they enact these ancillary copyrights, they are U.S. internet services that are exporting into those countries, and they represent the most prominent brands in the world, and they provide IP-intensive services, even if they are not selling cultural goods directly as their primary business model. Although I would add that many of these services do, in fact, provide platforms for the sale of cultural goods. So, there's, in my view, no question, there's no principled reason why we can say, if you're exporting CDs, you get services, but if you're exporting a different kind of service that depends on IP, that we're going to exclude that from 2242.
Thanks. Your second question comes from the Department of State.
Well, this is a really, really important question for all of us because, you know, at the State Department, whenever you ask for a new position or a new piece of equipment, the first question the management people always ask you is this the first time you've asked for that? And you mentioned that the issue with Australia includes a commitment they made a dozen years ago. And so I think the really relevant thing for this panel's consideration is whether there is some new feature or some newly detrimental impact of this particular requirement.
So, ironically, the United States might be in part the source of the newly detrimental impact. And in a lot of countries, we have urged countries to raise their IP norms with good cause. And only recently are we more aggressively insisting on the implementation of those commitments. And as we are finding, often when those commitments get implemented, they sometimes wind up producing liability risks for exporters of U.S. services into those countries because we haven't insisted on the same level of limitations and exceptions that we have here in the United States. So frankly, I'm quite concerned that limitations and exceptions such as the safe harbors that are in TP are implemented in Pacific Rim countries. So just by way of example, which of course includes Australia. If you look around the Pacific Rim, one probably need not worry as much about limitations and exceptions, although I will say there still are some cases, in part because IP norms have been somewhat under-enforced. As we raise that degree of enforcement, we need to ensure that the flexibilities that U.S. companies depend on in our very high enforcement environment are also available in those countries. Or what we're going to find is that we raise IP norms and we create a hostile environment for U.S. exporters because limitations and exceptions like fair use aren't present in those marketplaces.
Thanks very much, and thanks for your testimony. Next, if I can invite the Footwear Distributors and Retailers of America.
Good morning.
Good morning. Welcome. Please introduce yourself and begin your testimony.
Great, thank you. My name is Matt Priest. I'm the president of the Footwear Distributors and Retailers of America, and I'm honored and privileged to have the opportunity to spend a few moments with you talking about IP protection. Founded in 1944, FDRA represents the entire footwear industry, from small family-owned footwear businesses to global footwear companies. In all, we support over 130 companies and 250 brands, or 80% of total U.S. footwear sales in the United States. Our member companies manage supply chains that span the globe, providing them with hands-on familiarity with the importance of intellectual property and innovation. We are acutely aware of the need to aggressively challenge the failure of other nations to protect patents, trademarks, and copyright in both law and practice. After all, FDRA members incorporate cutting-edge designs and technology into their products and rely upon the integrity of their brands. As an organization, we support USTR's efforts to fight counterfeiting and piracy across the globe. These efforts support thousands of American jobs that are put at risk by such counterfeiting and piracy. In fact, global trade in counterfeits increasingly targets American footwear brands. The two most recent annual World Customs Organization illicit trade reports found that seizures of counterfeit footwear increased by 356% during the latest 3-year reporting period, and that footwear went from being the 12th most seized product for IP violations in the world to the 6th, which we think is a stunning increase over a 3-year period. FDRA members have noted 4 general concerns or trends globally, some of which have been noted by USTR in the past Special 301 reports. These include, number 1, often penalties are inadequate to deter criminal enterprises from engaging in trademark counterfeiting operations. In many countries, the penalties imposed on these enterprises are so low that they only add to the cost of doing business. Number 2, infringers often use express mail and postal services to deliver counterfeit goods in small packages, making it more challenging for enforcement officials to intercept these goods. Illicit websites and e-commerce platforms, the vast majority of which are based in China, ship counterfeit goods from the United States primarily using international mail services.